So, I did the articles for 5 years. You, as I say, won't be able to do that, but you do have other options. One of them is the summer clerkship scheme. Again, such is the skewed way in which the profession does these things these days, that's not always easy to accomplish, but if you can get a summer clerkship, it's worth doing. Simply because it gets you into a real-life legal office and gives you some real-life experience of what the practice of law actually is. At the end of the whole of that, I had to decide whether I wanted to be admitted as a solicitor or called to the bar. I had no doubt at all that I wanted eventually to be called to the bar. I never studied law with any other objective than that of being a barrister. I wanted to go to court, and I wanted to appear in cases, and I wanted to address juries, and I wanted to practice in that way. But I was, 22, 23 when I was admitted, and for somebody with the background that I have described to you, it was out of the question, simply to go to the bar, out of the question. Because I had no contacts, none of the things upon which you need to be able to build in order to make a successful career at the bar. So, I became a solicitor. And for 3 and a bit years, I was a staff solicitor on the staff of Abbott, Tout, Crewe and Wilkinson, not the monolithic mega firm that exists now, but a firm of somewhat more balanced proportions, may I say. And they had then the retainer for the NRMA, the association, and for the insurance arm as well. Every so often, you'd be sent out to one of the local courts with the NRMA list, which on an average day would be 30 or 40 pleas of guilty and perhaps 3 or 4 defendant matters. And believe me, that was as good a training as you could ever hope to get for appearing, getting up on your feet and doing the job, thinking quickly and flexibly and so on and so forth, in the way that the good advocate always has to do. You will have opportunities which you should pursue. The university, may I say, has a very good structure in place for career advising and placement, and you should use it to the maximum extent to try and open up practical experience of that kind. It doesn't really matter if you can only swing it for 6 or 7 weeks in the vacation or for irregular times otherwise. What's important is to get into a real flesh and blood practicing legal environment and get some experience. It doesn't matter how menial the experience is, it doesn't matter if all you're asked to do is to ask for an adjournment or to squabble with the other side about an adjournment or something simple of that kind. It doesn't matter, as long as it's getting you up on your feet, as long as it's getting you some practical experience in the office, teaching you in the only worthwhile way, which is a hands-on way, how a solicitor's office actually works in the real world. And so by extension, might I say at once, how practice at the bar is very largely governed. So I did that for 3.5 years, but always against the background that I felt I wanted to go to the bar. And I thought long and hard about going to the bar because then as now, that was not an easy thing to do. For one thing, you had to set up chambers of your own. You had all kinds of overheads, clerk's fees, rental for chambers, libraries, roads, all of those things had to be done from day one. And through the great generosity of another member of the bar who had some spare space, I was allowed to occupy that. It's the greatest act of open-handed generosity I've ever had shown to me. And so in that way I got my start, in the sense that I got somewhere where I could hang my robes and keep my briefs and see my clients and get started. And I did, and over the next 17.25 years, I practiced at the junior bar. And I had a large, varied practice. I kept it as general as I possibly could. So that's what I did. And for those 17.25 years, I worked, as every barrister does, extremely hard. The more successful you become, paradoxically, the harder it is, because you're getting the harder cases, you are getting more of them, the demands that are being made on your time are increasing. You really must understand that in practice, as a solicitor, even if you have the support of the structure of a firm but emphatically at the bar where you have no supporting structure really, apart from your own, you've got to be prepared to discipline yourself and to set your priorities. If you've got to be on your feet addressing the jury at 10 o'clock on Monday morning, you can't go to a party on Sunday night, and that's all there is to it. And you've got to realise that before you think of practising, in particular at the bar. It is not a glamorous, easy life where you just swan aimlessly and generally comfortably from case to case, like those people who we see in those very entertaining but deceptive television series of one kind and another. Life is not like that. But let me at once add this. I never once regretted doing it. I thought at the time, and I think still, that to practice at the bar is one of the great vocations in life. Why? Because you can't change the world, but every so often you have a case, and it's difficult, and you put your heart and soul into it, and in that way that one can't put into words, everything comes together. And that's what I did. And then I began to wonder whether I would apply for silk. People were kind enough to say, have you thought about doing it? Perhaps you ought to think about doing it. And so that seed was sown. In those days, if you wanted to apply to be Queen's Counsel, we didn't have senior counsel then, the thing was done properly, and a silk was commissioned by Her Majesty's representative in this state, the Governor, as one of Her Majesty's counsel for the state. Another historical accident by the Constitution being illiterate, but that also is another aspect for another forum and another occasion. And it wasn't easy to do, because in my day, if you took silk, you were signalling to all the world that you were only interested in doing cases which would carry two counsel, because in those days silk never appeared without junior counsel. But I thought that I would, and on the first occasion when I applied, my application was refused. It was refused because there had been a change of government, and the incoming Attorney General, who had been a solicitor rather than a barrister and had some queer ideas about barristers, had a rush of blood to the head and decided that he would only appoint, or more precisely recommend to the Crown the appointment of, perhaps 4 or 5 barristers from the private bar. And I thought, well, what am I going to do? And I thought the first thing that I would not do was find the tallest available building and jump out of the window. And I thought, no, everything in life happens for a purpose. And I thought, no, I won't. I'll just absorb that as best I can and apply again next year. And people were kind enough to say, we are very sorry and don't be discouraged, apply next year, which I did. And on the next occasion, my application was granted. And so I received a commission as one of Her Majesty's counsel in the state of New South Wales. And I did that for almost 10 years before I went to the bench. And then, as I moved past that dispiriting milestone of 50, I began to think about what the future would hold for me. And I had thought that I would like to be a judge. But you don't just put your hand up, at least you didn't in those days, and say, would somebody please notice, I think I'm ready to be a judge and I'd really rather like to have a go at that. You just didn't do that.